Welcome to Bury St Edmunds Unitarian Meeting House. This liberal and inclusive place of worship was built in 1711, so it stood on this site for over 300 years. The origins of this congregation lie with a group of dissenters who refused to conform to the rules of the Church of England. The break took place following the restoration of the monarchy after the Commonwealth period, with the return of Charles II from exile. The dissenters, 2,000 clergy among them, were forced out of the Church of England for insisting on their right to believe differently and their desire for a more democratic form of church government. They had to meet in secret, facing persecution for many years, until the laws against dissenters were relaxed. It's easy to understand, then, that human rights have been a central concern for Unitarians and our dissenter forebears throughout our history. It's appropriate, therefore, that we're addressing the topic of the Human Rights Act this evening. I'm Matthew Smith, minister at this beautiful meeting house in Bury St Edmunds, and I'm really delighted this evening to have with me Bruce Chilton from the Unitarian Penal Affairs Panel, your chair of that panel.
Hello, Matthew.
Hello. And Ian Speed from Bury St Edmunds Amnesty Group.
Hello, good evening.
And we're here this evening to talk about the Human Rights Act, the history leading up to the passing of the Act, and also the current controversy about government plans to repeal the Act and replace it with a British Bill of Rights. So I wanted to ask you first, Bruce, if you could say something about the background.
The Human Rights Act, 1998, which came into force in 2000, encompasses the Convention, the European Convention of Human Rights, which started really as a British invention, because the idea almost certainly grew out of the mind of the British prosecutors in the Nuremberg trials, in an effort to draw in those people to try and prevent what had happened during the Second World War and up to the Second World War happening again in Europe. And Sir David Maxwell Fyfe, that prosecutor, managed to draw in 1947, one of his friends, a Frenchman, if I remember rightly, Pierre-Henri Téguin, and together they looked at the draft, and it was pulling human rights out of the Universal Declaration of the United Nations at that time. So they started going, then they persuade the leading countries of Europe, particularly, and of course, the British, who were dominant in this. And so it really is a British idea, and it's a British carrying out. And if it's been said at that stage, it was a British imposition as a victor in the Second World War. So the idea that we're going to bring rights home to this country, when we actually formulated it and we imposed it on Europe.
Ian, if I can ask you, in fact, it was the Blair government, I think in 1998, which introduced the Human Rights Act. Given the European structures that we have, why was that felt to be necessary?
Well, you go back to 1953, when the European Convention on Human Rights was signed in.
Yes.
And this was the basis for all the human rights activities and issues for all the way through to 1998. And it was very, very difficult for an individual to get any satisfaction out of Strasbourg because of the cost penalties, because of the communication problems. And what Blair's government tried to do was to facilitate the taking action locally in the UK, and therefore streamlining the whole process and getting a much faster resolution to the individual cases.
There seems to be quite a bit of confusion in the public mind between the European Union, which is obviously very controversial in this country at the moment. We've got a referendum on membership coming up this year, and the structures around human rights and the impact of European courts.
Well, I think the first thing to realise is that, of course, the Convention predates the European Union by some way. With the Convention starting its drafting in 1948 and its adoption in 1953. Separately, you've got the coal and steel unions coming together, which the British were invited to join and declined to join. You can understand at the time they had the remains of the empire, they had the growing Commonwealth, they had pretty certain trade benefits from, and to commit to a European identification was contrary to their views. So just as they didn't join the convention in a full sense, they ratified it, they undertook it, but the systems worked very badly initially. The European Union was not something the British wanted to know about. They changed their minds within 7 years. The only connection, if you wish, between the European Court and the EU is around the Council of Europe, which is not really a European Union convention anyway. And comes out of the, nowadays we would think in terms of the Council of Ministers. They're the people who can force the judgments that are made by the European Court.
So do we really need to be seeing the whole business of European Union and our membership and the human rights issues to do with the European Court as really quite separate issues?
They're very different organizations to the point where the European Union is not a signatory. Unlike the individual countries, it is not a signatory and cannot be a signatory to the European Court of Human Rights. And of course, once again, one emphasizes the British nature of the European Court. The presidents of the European Court have been a collection of those who have ratified, judges who have ratified it. And I think the majority of years have been dominated by British judges.
Ian, can you tell us what really is the purpose of the Human Rights Act and Amnesty's view as to the significance and importance of that act?
It is fundamental to a lot of the principles. And as you know, Amnesty is concerned about correcting of human rights abuses in individuals throughout the world. So this is fundamental to it. It's one of the building bricks of their programs. The actual purpose of the Human Rights Act is to put an end to abuse by establishment, by organisations, by authorities, to uphold the position of the individuals. And they are very specific. I've got a list here. The right to life, pretty basic. Prohibition of torture and inhuman treatment. Protection against slavery and unforced labour. The right to liberty and freedom. A right to a fair trial. Respect for privacy and family life. Freedom of thought, religion and belief. Free speech and peaceful protest. No discrimination. Protection of property. All these things that we take for granted. But if we didn't have these things, then our life would be quite miserable. The purpose of the Rights Act is also to give guidance as to how to take action if there is perceived abuses. And that is about actually writing to the public authority, raising a human rights issue. If they don't get a proper response to that, then they would take them to court, and they don't get any, and the court can then enact new provisions to take care of that abuse of human rights.
So the British government has been very critical about the Human Rights Act, and it was in the Conservative manifesto to repeal the Human Rights Act and replace it with a British Bill of Rights. The Attorney General was speaking this week, and this is Jeremy Wright, the Attorney General. It's possible to protect human rights without the Human Rights Act, and in fact to do so better. That's what this government intends to do. Shouldn't we have confidence that our government is acting on our best interests in this regard?
If what the Attorney General is indicating is that they will withdraw from the Convention of Human Rights, I think that would be nothing short of disastrous. It would be a disastrous example of the way the British have behaved, having been the progenitors of the Convention. That may not be what he means, of course. What he may mean is that he would like to contain the Convention within some new statutory framework, just as the Labour Party put it in, or most of it in, a statutory framework of their own. However, I think the difficulty here is that having adopted in the Human Rights Act 1998 the Convention, and now operated for a lot of years, one has to say, is there some other motive in the government's proposals?
Yeah.
And I suspect, being not knowing, not having heard this, I suspect there is. And I think what it comes down to is that the British governments, as was indicated by the then Home Secretary, Jack Straw, and has been repeatedly said by him, and more than once by Tony Blair, when he didn't like the judgments of the European Court, what they have lost, they feel, is control. And by getting back into their own statutory framework, they can exercise control. Now, this is truly frightening stuff. Not only will the time of the convention be lost, its now established efficacy will be challenged.
Yes.
But it will be capable, and this is where it really comes into, although it doesn't have a statutory entrenchment, it will be capable of being changed at the will of the change of the government, or the will of the change of the House of Commons, albeit it might be held up by the House of Lords. In other words, we go back to the issue, the so-called constitutional issue of the British, this ability to, so quotes, act pragmatically by switching the thing around for advantage of someone or somewhere, or one party or another party, fairly instantly, which of course the convention, as it stands at the moment, does not have. You cannot dabble, as it were, with your own interest in the affairs of the convention and the way that the European Court of Human Rights deals it out.
Yeah. And Ian, I wanted to ask you, what's the amnesty view about what the government's trying to do and the assurances that have been given by the government?
It's difficult to know where they're coming from. Gove did issue a statement 3 weeks ago. He talked about two main issues. One was that the issue of British service people abroad not being fully protected for the acts that they might or might not do while servicing abroad. I don't know what he means by that. I know that there's certain activities about being brought to court in the UK about some of the things that have been going on within overseas conflicts. So that's one area. The second area he's talking about is adjusting the Act with regard to free speech. What he's saying is that there's been too much focus in the past on freedom of expression. He sees the bill refocusing from freedom of expression to private rights, such as data protection issues, such as property protection issues. And this is the interpretation that I think is scary for everybody, because this is the one that's going to really cut the carpet from underneath us. It's going to be the one that gets us.
What do you foresee actually potentially happening?
I see that this government has a proven record of supporting global business versus global peoples. And I see this as a means of criminalising free speech and demonstrations and protests, and from Amnesty, that is one of our major platforms for getting actions. We see that they will be trying to criminalise more activities of that nature. I think that's where they're coming from.
If the Human Rights Act is so important to ordinary citizens, as you suggest, there must be some examples that have already taken place of how that's benefited people in quite serious situations.
What you hear about in the media is all the wrong cases, the cases which are strange and create a bit of dissatisfaction and a bit of questioning. Most of the cases that you don't hear about are the ones, the success cases, the everyday cases that are taking care of vulnerable families, vulnerable people, aged people, mentally ill people who are having to bring human rights acts against the authorities, such as care homes, such as the police, such as the National Health Service, such as the prison service, because they're not getting action from these authorities. One of the worst and saddest crimes and the fastest growing is modern slavery and trafficking. And you don't hear much about that at all as to what's happening there. The Human Rights Act is the only protection against the exploiters of these poor people. So the stories you hear about are all the bad stories. You don't hear about success stories.
I think there was an example, was there, of also a couple at a care home who were being split up.
That's right. Well, I've got a list here of ones that I pulled out. Old people mistreated in care homes. I mean, who do they go to? Mentally ill people who are not properly diagnosed and are not taken care of. Homeless and pregnant. What did homeless and pregnant people do? Abused children, victims of crime and police inaction. Children and adults with learning disabilities. Who takes care of them? Many more family disabled challenge issues. That's the success story of the Human Rights Act.
And so it's been used in numerous occasions.
Absolutely. Oh yes.
I think it needs to be said that, of course, this is our home use of the Human Rights Act. Every signatory of all the countries that have joined the European Convention of Human Rights are under a duty to implement the Human Rights Act and the Convention's articles and protocols within their country. So, Human Rights Act isn't something you go to Strasbourg for. It's somewhere you go to the local magistrates' court for.
Exactly.
It's somewhere where you go to the district court or the county court. It's not something you have to go abroad for. They're with us now, as long as we have the Convention of Human Rights in this country. And as I said before, the worry is it protected? Is it safe enough? Is it entrenched against a change at the behest of big corporation or a sudden change of government?
Bruce, there's been a long-standing issue between the European Court and the British government about a ruling that the court gave about votes for prisoners. I'd like to ask you, as chair of the Unitarian Penal Affairs Panel, why should prisoners have votes?
I think there are two issues. Firstly, there's a legal issue of the way that the governments have responded to not a demand by the European Court of Human Rights to do something about votes, but have interpreted it in that way, and that has spread out, as it were, to the British population, that it's some sort of high-minded demand by this foreign body.
So that's not correct?
That is not, in fact, correct. What the European Court tried to do is to look around and look at what other countries in Europe are doing. And with the exception of a couple of the very eastern states in Europe, including Russia and Azerbaijan, the only country that doesn't have voting prisoners is the UK. Now, for example, Ireland, when called upon, instituted votes for all prisoners readily, and it's worked very, very well. The real problem underpinning this is a moral problem. And it's the issue of rehabilitation of prisoners. Because many of us argue, and indeed the Penal Affairs Panel is very strongly in this, that the only way of bringing somebody back into society is to give them back their civil rights as much as possible so that they can be involved with society, and as we understand and we can demonstrate, by being involved with society at whatever level you measure it, but particularly family, relatives, friends, organizations, churches, such as we belong to, by doing that, you draw them away from what sent them to prison in the first place. You rehabilitate them as members of our society. And it's always been seen that the voting right is very much being a member of society. But the British have somehow got this bee in their bonnet about it being some sort of just desserts in some way. And there is more than a suspicion that politically it's got something to do with rewarding the victims in some way. So it's some sort of further penalty that's
But the European Court is not prescribing how this should be implemented.
Not at all. The European Court is merely saying, look about you, look at the other European states that just across the channel in France. It's a judge's decision there as to whether those civic rights will be removed and for what period. The British have been invited to do the same, but they don't want to give that power to the judges. Well, the British know what the European Court will accept, and in their 2014, the Conservative proposal, they thought in terms of three figures. Firstly, that they would allow voting for all under 4 years imprisonment. Then the second argument was, no, they'll cut that back down to under 6 months. Mm-hmm. And the third proposal is they'll stick where they are, no votes at all. Mm-hmm. The court, yes, I think very likely, given the range of figures that we see across Europe, would accept as a fulfillment of their requirement with under 4 years. Mm-hmm. 6 months, I doubt if they would accept. Mm-hmm. That would be the lowest of any of the figures in Europe. Mm-hmm. And no rights at all is just, frankly, two fingers at the European Court. The Penal Affairs Panel say it's an integral part of our commitment to rehabilitating.
So, Ian, I think it's fair to say that the Human Rights Act and the European Court have taken a real hammering in the conservative press in Britain because of decisions that are perceived to be perhaps not in the public interest as the conservative press would define it. How do you react to the way that the Human Rights Act has been covered?
We've got two views. We've got the conservative press, the right-wing press, and we've got the liberal or left-wing press, and they're quite different. So really, the question that I got, and I don't know the answer to this, is why is the right-wing press, the conservative press, so gung-ho against all things European, not just the Human Rights Act, but also on the whole Brexit front as well, is very strange. And I don't understand why, frankly. I can't get to the bottom of it. I get the feeling that the British press of that order are prefer to play in a smaller pond and not because they don't have the sphere of influence that they would like to have as a part of mainland Europe, a part of the EU. So that's why they're hammering it. And I think the thing I don't get is why there is no connection directly between them and the businesses that they claim to support. So you know that The Guardian, for instance, is very open and very, very liberal with regard to quite sure about retaining the Human Rights Act. Now, I've got some figures here that can answer part of your question also. Some facts. 1.8% of cases before the ECHR relate to the UK. 1.8%.
Only.
60% relate to Russia, Ukraine, Italy and Turkey. 98% of UK cases brought before the ECHR were struck out immediately. 13 cases were found for. So there's no high incidence of these weird cases that we keep hearing about. And let me just give you one other fact as well, which I dug out today, and that is from Reporters Without Borders, the World Press Index on Freedom of Information. The UK came 34 in the world, 34th from the top. Number one is Finland. 9 of the top 10 are mainland Europe.
So this is what, for respecting human rights?
This is for index on freedom of information. Freedom
of information, yes.
And the UK was at number 19 in 2010, so they've gone worse by 15 places in 4 years. So this kind of says a lot to me with regard to what it is that's not being said also.
Ian, I'd like to ask you in a moment about the Amnesty International's attitude to or view of the possible international ramifications of Britain replacing the Human Rights Act with a British Bill of Rights. There's a very strong quote here from Kate Allen, who is Amnesty International UK Director. She says, "There's no doubt that the downgrading of human rights by this government is a gift to dictators the world over and fatally undermines our ability to call on other countries to uphold rights and laws." And there is, interestingly, a very recent quote from the President of Kenya, Uhuru Kenyatta, International Criminal Court has raised questions about Kenyatta in relation to post-election violence in Kenya. He's recently quoted as saying, "The push to defend sovereignty is not unique to Kenya or Africa. Very recently, the Prime Minister of the United Kingdom committed to reasserting the sovereign primacy of his parliament over the decision of the European Human Rights Court. He's even threatened to quit that court."
Kate Allen got it exactly right, and you can tell from the response from Kenyatta that dictators throughout the world are really taken on to this idea. It seems that this current government has turned inward on itself and is looking internally instead of looking at the role it used to have in the world instead of a major player, not just in Europe but in the world itself. And the example that it set to these developing nations in regard to what their constitution should be in terms of freedom, liberty, human rights. And suddenly they see that this guy is giving up on all that stuff and going back on himself. These dictators are not voted into office. Many are there for life because that's the way they've got it structured. Now they suddenly find they don't have to care about human rights either. The second thing as well, I would say, is that we've got this terrible crisis in the world with regard to non-economic refugees and stateless refugees. Now, to have a human right, you've got to have a state. And if you don't have a state, then you're nowhere. And that is an absolute disgrace. And that nobody is tackling this situation at this point in time.
At the end of the war, when the convention was thought of, 15 million were dealt with successfully by the same European nations who now cannot come to agreement on dealing with, approximately 1 million.
Yeah. Mm-hmm.
And that, I think, is a political failure.
Yes.
And what really I see again, going back to I think what is the central point, although nobody wants to say so, is that the history of the British of the last century has been one of great respect for international commitment and international treaties and obligations at its peak. And then at other times, that seems to have slipped away to the bottom. And it seems to me, just as Ian has said, that we're sliding in that direction. To give up the protective element of the Convention of Human Rights seems to me to be a very dangerous thing to do.
We're now in the run-up to a referendum on Britain's membership of the European Union. I'd be interested to know whether you think this may have some impact on the decision that's ultimately taken about the Human Rights Act. And related to that, where do we think the government is going? What is going to be the process?
Gove has submitted his documents to Cameron. Cameron has them. Cameron will do nothing with them until after the referendum. That's pretty clear, because it's going to be such an unpopular move in the UK and in Europe that it could well affect the actual referendum result. So he will do nothing until after the referendum. The next question then is, what is the scope of it after the referendum? And it might even depend on what vote he gets, whether it's Brexit or otherwise. I'm not sure about that, but we do know that Scotland will opt out of any changes. We do know that the Lords is likely to knock back any kind of submission. It depends on the extent and the scope of the change. It now seems likely that it's going to be a matter of interpretation rather than of real substance. And so I think that we don't know. We just have to be very vigilant about making sure that we are ready to react as soon as we know that something is going to happen.
I think the most important point is at the moment we simply don't know what the government's intentions are. If we follow the Attorney General, then we may well be looking at losing that protection of the Convention of Human Rights. That if one has a regard for human rights, we must be ready to make that protest very clear, that we have enjoyed the protection, we have enjoyed its protection over the years and the rights that it's given us. The final word, I think, really rests with two elderly judges in the 1960s, Lord Wilberforce and Lord Bridges, because they said that the way we are now, British liberties are what we get where the British Parliament does not make a statute removing them. Now, in the time that I've been a lawyer, not since the 1950s or 60s, but certainly since the 1970s, when I began my apprenticeship in law, my law book in the court was that thick. It is now something I couldn't pick up. A tremendous increase in the number of offences, tremendous increase in the amount of legislation made by the British government. And this is not at the behest of the European Union or the European Court. This is the way that the British have decided they're going to run their processes.
And we've got to have questions about that.
And we've really got to be able to keep what we now have established as our rights rather than our liberties. The very few the liberties that one can see between the cracks in the statutes.
Right. Thank you. I'm just going to say to Bruce and Ian, thank you very much.
Well, my thanks to everybody involved in making the film, particularly Jez, who it was the first time that he came on one of the trips to help with the filming, and I'm sure he'll be helping again with it. Apparently I was rather quiet beforehand, so we've turned the volume up here and I hope it's much better now. This month we are going to Golders Green and we're going to be filming a debate on LGBT issues. Whether that comes to you next month or the month after, I'm not quite sure. We are also filming in Lewisham a cycled service, and we also have a youth film to show you at some point, which is how they created and delivered a service at Forward. But thank you very much for watching. We are not sure of the numbers of people that have actually been able to view tonight because the numbers aren't working, but we don't care about things like that. We just hope that each month we can bring you something, and slowly but surely we improve the standard. So thank you very much indeed for watching, and we will see you next month. Thank you very much.